Okay, so the case presented before us was Schuette v. Bam. I personally don't think that Seattle has absolutely any bearing on the facts presented at oral arguments and after reading the briefs. What do you guys think?
I agree. Seattle and Hunter reflect important principle that an individual's ability to participate meaningful in the political process should be independent of his race, but that doesn't apply here because those cases are involving a restructuring of the political process that changed the political level at which we were, at which these policies were enacted, while the case before us here involves an amendment that took the decision-making authority away from unelected actors and placed it in the hands of the voters.
Exactly.
But the thing is this, I believe that the court here, that I'm disagreeing with the reinterpretation of Hunter in Seattle, because you're making them stand in part for the cloudy and doctrinally an atypical proposition that whenever state action poses the serious risk of causing specific injuries on account of race, it's denying equal protection. I reaffirm that the ordinary principles of law and our democratic heritage require plaintiffs alleging equal protection for violations, which stem from facially neutral acts to prove intent and causation, not merely the existence of racial disparity.
Okay. But in Mulkey, Hunter, and Seattle, there was actual risk of purpose of causing specific injuries on account of race. That isn't the case here, but you obviously feel differently.
Well, the thing is this, in Hunter we held equal protection was denied when the Akron City Council passed an amendment that there must be majority voting electors referendum approval on all ordinances that regulate real property commercial transactions.
Okay.
But extending the holding of Hunter and Seattle to situations where decision-making authority is moved from an administrative body to a political one would create significant difficulties, given the nature of the administrative process.
Well, that's what I'm agreeing with here. And that's why I believe that the interpretation or reinterpretation by the majority of this court is what's wrong. I mean, I concur with the decision here in this case, but not with how we get there.
Okay.
Exactly.
Because Hunter and Seattle actually should either have been overruled in this case, or we needed to properly apply that political doctrine.
Okay.
What about you, Justice Ginsburg?
I think the same thing as far as when we have a beginning case and the policy of matters, we should really go forward with that. But then as soon as we try to intervene, we need to, as judges, take police action if we find that something is going wayward. And so we need to, as justices, step in and intervene and make sure that we are continuing on the correct process.
But this police action that you're referring to, do you not feel that this is going to infringe on the voters' First Amendment right to free speech and to a free democracy and trust in their legislatures to...
I don't believe so. As far as dissenting, what do you think on that? I don't believe so.
Well, I think it is. I don't believe that this violates the 14th Amendment. The Constitution permits, states to use race-conscious admissions process, but it doesn't require it. So if the states want to choose not to do that, who are we to say they can't?
Well, I'm sorry, but with regard to you, Justice Sotomayor, I disagree with that position because once a lower branch of government exercises a higher government's authority, then the state's sovereign power would be forever preempted to address a matter of compelling concern to the state. So should we not allow local subordinate authorities to have more power over the use of race-based preferences than the voters of the state?
I don't. I think that's subjectively speaking, and everyone has their own opinion, but I don't. I think that we as justices were put in this position to help guide our country, so to say, and that we should step in and take the action that's correct.
Okay, well, from what I gather, from all of us, it's looking like the majority is going to rule in favor of the state of Michigan.
I agree, but I believe this for different reasons.
Okay.
So I will be concurring in the judgment.
Okay. Well, myself, Justice Kennedy, Justice Roberts, and Justice Alito will go ahead and we'll draft up the majority opinion, and we'll deliver that.
I would like to make one final point as far as my opinion goes, that the political restructuring doctrine doesn't apply here. Michigan took the decision over race-based admissions preferences out of the hands of the unelected school administrators. By mandating equal treatment at the constitutional level, Michigan voters have made this decision more political, not less.
Yeah, and Justice Scalia, with whom, Justice Thomas is agreeing, I believe the question in this case, as in every case in which neutral state action is said to deny equal protection on account of race, is whether the action reflects a racially discriminatory purpose. Seattle stresses that singling out that political processes affecting racial issues for uniquely disadvantageous treatment inevitably raises dangers of impermissible motivation. True enough, but that motivation must be proved, and respondents do not have a prayer proving it here.
Okay.
Judges should not be in the position of dividing the country into racial blocks and determining what policies are in each one's interest, nor should we allow local subordinate authorities to have more power over the use of race-based preferences than the voters of the state. So I concur in judgment, but not in the reasoning, and Hunter and Seattle should have been overruled.
Justice Ginsburg and I dissent.
Okay, let's go deliver the opinion.